This case is about perception. The Constitution of our country embodies the right to be able to defend ourselves. And there's a wisdom in our laws that begins with this concept of perception. It's central to self-defense because the law protects that reasonable perception. The law demands that we assess the reasonableness of that perception, not from the comfort of a courtroom. But we have to take ourselves back to the perspective of the moment itself. The law requires each and every one of us to look at the circumstances that Susan Lorincz was facing on June 2nd of 2023. She was almost 59 years old. She was in her home where she lived alone, a troubled neighborhood to say the least. It was nighttime. She was suffering from a multitude of medical conditions when she was startled by a barrage of screaming of profanities and banging on her door so hard that the walls were shaking in a cement block house. Now, the judge has gone over with us some of the law in this case, and it's very, very important, particularly when we are dealing with self-defense. And I know Mr. Buxman went over a little bit. I need to go over it with you, and this is the only opportunity that I have to speak with you, so just bear with me. In jury selection, the judge talked to us about this plea of not guilty and reasonable doubt. And he sort of went over that instruction, and he gave it again, and there's a reason that it's one of the first instructions that we get. It's sort of the foundation of our system of justice. So what does it tell us? It tells us that Susan Lorincz has entered a plea of not guilty. This means you must presume or believe that she is innocent. So we start there. We start with the fact that she's innocent, and where does it go? Where does that presumption go? It stays with the defendant as to each material allegation in the information through each state of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. That's pretty powerful language for the protection of our liberties. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. We talked about this term reasonable doubt in jury selection. I'm not going to read the whole definition to you again. The judge gave it to you again. And it's very important. And what is reasonable doubt? It means you have to be sure. Really sure. The law says you should only convict someone if you're convinced they're guilty beyond a reasonable doubt. You should feel confident in your decision without hesitation. So if there's something in the evidence that gives you pause, if you're back there and you're deliberating and you're thinking, man, she was an older woman. She had some medical issues. She did live alone. She had these prior run-ins with Ajike. I could see how she could be scared of her. And you're thinking, I did see the damage on that door. That's reasonable. I could see how she could be afraid that she was going to get through. If you're back there and you're pausing and you're hesitating, if you're wavering and vacillating, that's reasonable doubt. And if you have a reasonable doubt, you should find Ms. Lorincz not guilty, because that is what the law says. And each and every one of you took an oath to follow the law. So where do we look for reasonable doubt? It is to the evidence introduced in this trial, and to it alone. Only the evidence introduced in this trial and nothing else, that you are to look for that proof. It may arise from the evidence, the conflict in the evidence, or the lack of evidence. And if you have a reasonable doubt, you should find the defendant not guilty. Justifiable use or threatened use of deadly force. This is a very, very important jury instruction. You're going to get to work with this when you're deliberating. The laws in Florida give citizens the right to defend themselves when they are faced with imminent danger. Deadly force means force that is likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. And the most important thing in this part of the jury instruction is where it says, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. So they not only have to prove to you that she committed this manslaughter, but they also have to prove to you beyond a reasonable doubt that she was not justified in using deadly force. Now, Mr. Buxman went over this, Judge Hodges read this to us, and there's a couple important parts of this jury instruction that we need to focus on. And one is, if Susan Lorincz was in a dwelling in which she had a right to be, she had no duty to retreat. If you remember during the trial, Mr. Smith had asked some of the witnesses, did Susan shoot from way back there by her bedroom? Did she shoot from behind that countertop or behind that kitchen? It doesn't matter, because she has no duty to retreat, and she can stand her ground when she is in her dwelling if she is faced with imminent danger. Another important part of this is if she reasonably believed. We do not judge Susan Lorincz with what we in this courtroom have experienced in life. It's not what I would do, or Mr. Buxman or Mr. Smith would do in that circumstance. It's what Susan Lorincz reasonably believed was necessary to prevent. That's a very important word, prevent. The law does not say that you have to wait to get punched or attacked before you can do something. That's not what it says. You can use deadly force to prevent someone from coming into your home and hurting you or attacking you. Because members of the jury, if someone who is on the outside of your door that is banging and pounding so hard wants to get in that house and they do, it is too late. There are way too many variables if someone actually gets inside. Your gun could jam. You could get rushed. You could fall, especially if you have medical conditions. So the law accounts for that. You can do what you need to do to prevent that from happening. What was Ms. Lorincz confronted with on that night when she had to make a split-second decision? We heard from Dr. Roy Bedard. He's a world-renowned use of force expert, trains law enforcement officers all over the country, and he talked to us about how someone reacts under stressful situations, these high-stakes decision-making, and he told us that when there's high consequences, you don't really know if the person on the other side of the door or the person that's confronting you is armed. Not just Susan Lorincz, but most people go to the fact that this person is armed, that they are a real threat. That's reasonable. And Susan Lorincz had no idea what Ajike Owens had on her. He told us that biologically, what happens in your brain and you're stressed, and you have these high anxiety situations, and it's releasing all of these things, your adrenal glands, and it's a high stress situation. And people have to make life or death split-second decisions when they're going through these things. He told us how a person perceives time differently. That something that was a second may have actually been a minute. And he told us that if someone's older, or if they have prior negative dealings with somebody, all of those things can affect their decision making. it's very difficult for someone to judge what is going to come next. And the law says that Susan Lorincz can defend herself to prevent the imminent commission of burglary, murder, or aggravated battery against herself. So this sort of lays out the definition of those things, and I'm not going to read it all again. But there's an important thing that I want to point out about the crime of aggravated battery. It's defined as intentionally touching or striking another with a deadly weapon, or intentionally or knowingly causing great bodily harm, permanent disability, or permanent disfigurement to another. We heard from Dr. Norford, the medical examiner in this case. And on cross-examination, she told us, yeah, I mean, if somebody is hit or kicked or punched, and that person is older, and they have medical conditions, that could cause great bodily harm to them. So if Ajike Owens gets through that door and just punches or kicks or hurts Susan Lorincz, that could cause her great bodily harm. We heard the statement that Susan Lorincz gave to law enforcement. We heard two of them. And Miss Lorincz told detectives on the night of that incident she was pounding, Miss Owens was pounding on her front door so hard the walls were shaking. She told detectives that Miss Owens was screaming at the top of her lungs and that Susan told her, "You're trespassing, you need to leave." Susan Lorincz told detectives, "I really thought she was going to break my door down. I really thought that. I saw the door moving in, and I really believed that. I honest to God believe that." That is what she said. She reasonably believed that. We heard Susan tell the detectives, "I heard Miss Owens say, 'I'm going to kill you.'" She heard that. Miss Lorincz told them, "I heard the door crack. And when I heard that door crack, I fired." We heard from Joshua Wright, the ballistics expert, and he sort of worked in conjunction with Toby Terpstra, and they created this 3D visualization that you saw. And what's important about Mr. Wright's testimony is that it's consistent with what Susan Lorincz told detectives. "I was standing back near the table. There's no evidence that she moved the shell casing or did anything like that." It's consistent with what she told them. Miss Lorincz told them, "I wasn't going anywhere near that door. I was terrified it was going to come down." And he told us, yeah, it's pretty likely that Susan was standing by her table when she fired the gun. So, how do we decide whether somebody is justified in using deadly force? And this paragraph sort of guides us in that, and it tells us that you must consider the circumstances at the time the force was used. All of it. The fact that she's in her home, she's alone, it's nighttime, her knowledge of Ajike Owens and her past interactions with her, the noise level with the pounding and the screaming of the profanities, the problems that Susan Lorincz was having physically, all of it. You have to take into account those circumstances. It's what she would reasonably do. The beauty of the law is that it does not punish individuals that reasonably perceive that danger. Now let's talk more about that danger, because the law goes one step further and it tells us that the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. And we know that it was real to her because we heard her in her statements to detectives. "I really thought I heard that crack and she was coming through that door." She just believed that. And if she believes that and she perceives a danger and that danger is reasonable in her shoes, she can defend herself. She does not have to wait. So was it reasonable for Susan Lorincz to think that she was in a dangerous situation where she could be hurt or killed? This is what was standing between Susan Lorincz and Ajike Owens on June 2nd of 2023. Ajike Owens was a 35-year-old woman who was 5'7", weighed 293 pounds, and was very, very angry at Susan Lorincz. A door frame that was broken and barely hanging on. Now we heard from Charles Gabbard. He told us, I tried to fix this door as best as I could. I put some screws in it, put some putty in it, and it was structurally sound. He made a point to let everybody know it was structurally sound. Not really sure how he knows that. He didn't really do any testing. But he wants everybody to know, this is not my fault. As a landlord, that door was structurally sound. But it doesn't really matter whether it was or it wasn't. What matters is that Susan Lorincz knew the shape of the door and what it was like on that day. And she believed that door wasn't going to hold up. And was it reasonable for her to think that? Absolutely. All we have to do is look at the photos. The crack goes all the way down the frame. Almost all the way down. Was it reasonable for Susan Lorincz to hear a crack when Ajike Owens was banging so hard on that door? Absolutely. Miss Owens was a woman who ignored not one, you see the no trespassing sign on the window, not two, but 3 no trespassing signs. 3. And we know this was not the first time that Ajike Owens had trespassed on Susan Lorinc's property, and we'll get to that a little bit later on. Miss Owens was very, very angry. How do we know that? What evidence tells us that? We know that there was an interaction that Susan Lorincz had with Ajike's sons, Israel and Isaac. Susan talked a little bit about it in her statements to detectives. There was an issue with a tablet and a pair of skates and an umbrella. And Miss Owens went over to confront Susan Lorincz about it. And we heard from Yaro Rodriguez, and he took the stand and he told us, Miss Owens was mad. Yaro Rodriguez told us Miss Owens' tone was a loud and a mad one. He told us Miss Owens was screaming and using words like, and he told us, at first he didn't admit it. He was like, I didn't see her knock on that sliding glass door first. But we reminded him, you gave us a deposition and you told us about these things. And he said, yes, actually, I did remember. I did see that. So she went straight to this sliding glass door and she started pounding as hard as she could. And we heard from Jareth Gardner. And he told us that he was over by the basketball hoops, and when Isaac and Israel came up to him and told him something that had happened at Susan's house, and he told us one of the kids said, go get AJ. He didn't really want to tell us, but he admitted, yeah, she seemed frustrated. Miss Owens seemed frustrated. And that he heard Miss Owens knocking, and then knocked again, but this time it was louder. He told us that he heard Miss Owens say, open the door. And he told us that Miss Owens' demeanor was like somebody had just messed with her kids. And he told us that even he started walking over to Susan Lorinc's home because he felt the energy and he knew an altercation was about to happen. This was not a woman that was coming over to have a nice chat with Susan Lorincz about what had happened with her children. We cannot ignore the realities of what happened that night. The state may compare this to someone just coming on to the little, come on, Susan, I want to talk to you about what happened with my kids. That is just not what happened. Miss Owens was screaming so loudly that Rosalie Smith, a neighbor that lives a football field away, heard her. She said it was so loud. So if you can imagine how loud it was for Rosalie Smith, who was a football field away, imagine what that felt like for Susan Lorincz, who was right on the other side of that door with that broken door frame. Miss Smith told us it wasn't just 3 bangs and then another 3 bangs. She told us it was a lot of pounding. I mean a lot. And that it felt like even to her it went on forever. Yariel Rodriguez told us Miss Owens was banging on the door hard, and she was banging with her fist. I mean, he told us this is what I saw, and that she was banging in the middle of the door. And we heard from a really important witness, Yvonne Costa. The state called her as a witness, and that's Susan's neighbor that shares that wall with her. And she told us that all of a sudden she heard a banging that was really, really bad. I mean, so bad even her walls were shaking. So bad that she was scared. So it's not just Susan Lorincz saying, man, that banging was so loud, I was scared. Her neighbor says, I was terrified. That's how hard it was. She told us that the banging stopped, and then she heard it again, and then at this time it was even worse. And that there was a lot of it. A lot of banging. Not just 1, 2, 3, 1, 2, 3, a lot. She told us that while she heard the banging, she heard voices. Loud, aggressive, very guttural and deep voices, and that it sounded like it was coming from outside. Miss Owens was angry. And if she got through that door, and Susan Lorincz thought that she was going to because she saw it moving in and she heard that crack, she was in fear for her life. Ajike Owens was trespassing on Susan Lorinc's property. And Susan Lorincz was in her home where she had a right to be, and she had no duty to retreat. She had a right to stand her ground and defend herself because she was reasonably afraid. Now, the state may say, well, Susan Lorinc's fear, that wasn't reasonable because Ajike Owens never got through that door. She didn't go over to Susan Lorinc's house to harm her that night. She just merely wanted to go onto her porch and talk to her. They may say, well, did she trespass? Maybe. She never intended to harm her. But the law on self-defense accounts for situations just like this. Situations where someone unlawfully and forcefully comes onto someone else's property. The law tells us, hey, there are certain circumstances where if certain things happen, you can presume that someone has a reasonable fear. If certain things happen, you can presume that the person was going over there to cause harm. And these next 2 slides, they deal with that portion of the law. And we sort of have to read these in conjunction with each other, and so I want to go over the definition of dwelling. And this is something that Mr. Buxman didn't talk about, and this is really important. So dwelling means a building or conveyance of any kind, including any attached porch. Whether the building or conveyance is temporary or permanent, or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. So remember that includes any attached porch. So when we go back and we're looking at this, the person against whom the defensive force was used, aka Miss Owens, was in the process of unlawfully and forcefully entering, or had unlawfully and forcibly entered, a dwelling. So a dwelling includes an attached porch. So did Miss Owens unlawfully and forcefully step onto that porch? Absolutely. Not the door. We don't have to wait for her to get inside the actual house. The patio is part of the house. The law tells us that. So did she unlawfully go there? Absolutely, she was trespassing. Did she forcefully go onto the porch? Absolutely. How do we know that? Yariel Rodriguez, Jareth Gardner, Rosalie Smith, Yvonne Costa. She's yelling. She's angry. She's loud. She's banging. That's forcefully. That's what makes this different from someone like an Amazon driver coming to deliver a package. Miss Owens forcefully went on that attached porch, and that's the dwelling. And if that's the case, we have to presume that Susan Lorincz had a reasonable fear, because the law tells us that we have to. If that's the case, we have to presume that Miss Owens was going over there with the intent to commit an unlawful act. We have to presume that. We don't get to guess that. Well, maybe she wasn't going over there, she was just trespassing. No. The law says if she unlawfully and forcefully entered that attached porch, we have to presume she was going over there with the intent to do harm to Susan Lorincz. This slide is really important. If you find that Susan Lorincz, who because of prior threats or difficulties with Ajike Owens had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Ajike Owens, you may consider this fact in determining whether the actions of Susan Lorincz were those of a reasonable person. So let's talk about those prior incidents that we heard about. So Deputy Coleman testified. The state called him as a witness, and he told us, yeah, I went out there in February of 2022. And he told us, Susan Lorincz told me that Ajike Owens had battered her with the trespassing sign, hit her in the leg. And Deputy Coleman spoke to Ajike Owens, and he told us that Miss Owens told him, my dog likes to defecate on Susan's property. That's his favorite spot, and I don't care. That's where he's going to go. And unless she can show me a deed or something other than that, that's where he's going to go. Deputy Coleman talked to Miss Owens about this interaction that she had with Susan Lorincz. And Miss Owens again told the deputy, yeah, I told her, I don't care about your sign. I can go get myself a sign if I want. I don't care about it. And she admitted to Deputy Coleman, yeah, I threw the sign. Deputy Coleman told Miss Owens, look, even though she's renting, that is not public space. That is private property. You cannot go over there. If you have an issue, call us. Coleman told us that he saw a red mark on Susan's leg, but despite that, he never arrested Ajike Owens. But we heard from London Remy, though, right? She was there and she saw this. She told us. I saw the sign hit Susan's leg. I mean, it barely hit her, but it hit her. For whatever reason, deputies decided not to arrest Ajike Owens. Deputy Coleman told us that Susan Lorincz had taken a photograph of Ajike Owens when they were having this confrontation. And This was entered into evidence, and it was stipulated to that this is the photo that Susan Lorincz took of Ajike Owens on February of 2022. Now, we also heard from Shelby Kinsey, and she was another deputy that had responded out in December of 2022 because of another altercation between Ajike Owens and Susan Lorincz. And Deputy Kinsey told us, I spoke to both Susan, I spoke to a mother, didn't even get her name, but spoke to a mother. We later learned it was Miss Owens, and Miss Owens told Deputy Kinsey, yeah, my 9-year-old son was mouthing off to Susan Lorincz. Miss Lorincz had told Deputy Kinsey that Miss Owens came to her house, knocked on her door, and said, if you treat my son like this again, I'm going to rip your ass out of your house and beat you up. Again, on that night, Miss Lorincz told Miss Owens, you are trespassing. Please leave my property. But Miss Owens didn't leave again on that night. She said, I have my son here, and I'm just going to talk to you about what happened. Susan Lorincz said, get off of my property. And when she felt threatened, she called the police, and that's when Ajike Owens left. Deputy Kinsey told us that Miss Owens herself said, Susan told me I was trespassing. Leave. I didn't leave. I wanted to talk to her about what happened with her and my son. Deputy Kinsey told us that Miss Owens herself told her, I said to Susan, if you walk up on my sons again, you're going to have to deal with me. Those were Miss Owens' own words. Once again, Miss Owens wasn't arrested, and Deputy Kinsey told her, you can't go over there. If you have an issue, call us. In her statement, Susan had told detectives about another time that Miss Owens had followed her a couple months before this incident, where she was like a foot behind her and she was following her almost all the way into her house. And that's the reason why Susan Lorincz had all these no trespassing signs up, members of the jury. She just didn't want people on her property. Now, this slide and this part of the jury instruction sort of deals with that same premise of if there's prior interactions between Miss Lorincz and Miss Owens. And this talks about, if you find at the time of the alleged manslaughter by use of a firearm, Susan Lorincz knew that Ajike Owens had committed an act or acts of violence, you may consider that fact in determining whether Susan Lorincz reasonably believed it was necessary for her to use deadly force. Now, Mr. Buxman said, well, threw the sign, hit Susan Lorincz in the leg. London Remy told us that it did, but who cares? It was a flimsy little sign, no big deal. Maybe it's not a big deal to him, but it could be a big deal to Susan Lorincz as she's experiencing a traumatic situation, and it's something you have to take into account, and she knew that she had been previously battered by this woman. It was a big deal to her, to Susan, and that's what matters. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Susan Lorincz and Ajike Owens. Why does the law do that? Because it recognizes that a 35-year-old, 293-pound woman is much more dangerous if she gets her hands on a 58-year-old woman with the physical problems that Susan Lorincz had on June 2nd of 2023. Ajike Owens has much more capabilities, and Ms. Lorinc's medical records are in evidence, and you can take your time when you're deliberating and you can go through them and look at all of those things. And we heard Susan talk about all of the medical conditions that she was suffering from when she spoke to detectives about her cervical fusion and her bad knees. her knee going backward, and all of those things. The law says you have to take those things into consideration. I want to play this visualization for you one more time, but as you're watching it, and as it transitions into the part where Susan Lorincz is in her home before she fires, I want you to focus on the door. Now, the state asked, I believe it was Mr. Smith, they asked Toby Terpstra, you took some liberties with making this video. That video was created based on Susan Lorinc's statement to detectives, where she told them multiple times, I saw that door coming in. I saw that door moving. She says that multiple times throughout her statement. That is what she said. So you can imagine how she sees this door moving the way that it is, and she knows that the door frame is damaged. How scary that must have been for her. And she had a split second to make a decision whether or not to fire her weapon. The state asked some of the witnesses about Susan Lorinc's demeanor after the fact. Made it a pretty big deal about, she asked about her cats. They asked another witness, how did she seem? She's like, well, I mean, I don't know. Is it really that unreasonable for someone as a pet owner who has two cats to just say, hey, can you just close my door so that my cats don't run out? Because she asked that question, that must mean she wasn't in fear. And I want to address this. This is my only chance to speak with you, and Mr. Buxman may get up and speak, or he will get up and speak after me, so I want to address this just in case. In her interview, Susan Lorincz, they ask her questions about her researching Stand Your Ground. On that second interview from June 6th of 2023. But if we go back and we remember, during that June 3rd of 2023 interview, the detective says to her, the law says it has to be imminent. And he's explaining to her sort of the law, and she's like, okay. Is it reasonable for someone to leave that interview and go and research? Like, man, I wonder what the law really says about this. Is that reasonable? Absolutely. The state argues that Ms. Lorincz knew that law enforcement was on the way, but we know it took law enforcement almost 15 minutes to get there. 8:54 is when she called 911. First officer didn't respond on scene until I believe it was 9:08. A lot can happen in 15 minutes, members of the jury, when you are in fear for your life. A lot. One of the last times the police came out, when Susan Lorincz told them that she had been battered, they didn't even ask Ajike Owens her name. The state says it's only 2.5 minutes Only 2.5 minutes had went by. But Dr. Bedard, he talked to us about that perception and how that can feel like a very, very long time. And the state introduced some videos that Susan Lorincz had taken earlier in the day, and they had introduced this umbrella, and they introduced these skates. Even Mr. Buxman in his closing admitted, like, none of that even really matters. But they took the time, they introduced those things. Why do they do that? Do these skates, the umbrella, these videos, prove to you in any way that Susan Lorincz wasn't reasonably afraid? Because remember, they have the burden to prove she wasn't acting in self-defense. During the trial, Mr. Smith made it a point to ask some of the witnesses, particularly our expert, Joshua Wright, did you see there could have been gunshot residue on the door? All the stuff about the gunshot residue. Did their crime scene tech ever test the door for gunshot residue? Did you ever hear any of that? It took law enforcement over 2 weeks to even go out and collect that door and place it into evidence. And by that time, Charles Gabbard had already got his hands on it, sanded it down, filled it in, painted it over, before they even collected the door and placed it into evidence. A door that they made it a point to ask the witnesses, was there any dents, any scratches on it? Waited 2 weeks after Charles Gabbard had done work to it to even collect it. So I want to talk to you just a little bit, and I'm almost finished, about the state's burden. And I want to show you a little bit about sort of how that means, or what that means. If you are anywhere along this chart, other than the red part at the bottom, you have to find Susan Lorincz not guilty. If you think it was self-defense beyond a reasonable doubt, she's not guilty. If you think, man, this might be self-defense, that's not guilty. Even if you think it probably wasn't self-defense, that's not enough. She's not guilty. It's not until you get down here where they've proven to you beyond a reasonable doubt that it was not self-defense, that is the only way that you can find her guilty, because the law says so. Now this is the verdict form, and this is what you're going to see when you go back there to deliberate. And based on all of the facts and evidence, when you get back there and you're deliberating, we're going to ask you to check that box B. The defendant is not guilty. Thank you.